screen of the application contains North-East Adoption and Fostering Services Limited and the Office for Education, Children's Services Executive.
Thank you. Mr O'Neill, Mr Silverson, can we thank you for the note received overnight, which we've read, and it's helpful in answering my lady's question from yesterday. Thank you.
Obliged, Lord. And there is, in preparation, also a short witness statement, which, in a sense, covers 2 points raised yesterday by the Lady Justice Davies and Your Lordship. There has been a subsequent Ofsted inspection and report which deals with, in a sense, the remediable matters that were raised, and we're just putting that in as well with an accompanying witness statement, and also some explanation of the holidays and events issues which was raised. It's only a couple of paragraphs, but it's been
well, shall we for the moment leave it on this basis? It's obviously matters come up in the course of a hearing. They don't normally lead to the production of evidence during the course of a hearing, but if you have an application to make, you'll make it when you're ready to make it, and we'll deal with it on its merits.
Indeed so.
But thank you for explaining that. Thank you. Yes, Ms. Hannett.
My lord, my ladies, the structure of my submission will be in two broad parts. I intend first to give you an overview of the Equality Act, to take in effect a zoom out, but in the course of that I will zoom in on two discrete aspects. First of all, the definition of sexual orientation, and secondly, the meaning of direct discrimination. I then propose second to turn to address the grounds. I'm going to take them a little out of order by dealing with grounds 2 and 3 first, if I may, the Equality Act points. That follows on more logically from the analysis of the Equality Act that I'll take you to first. I'll then turn to look at ground 1 on the Charity Commission point, and then finally I'll deal with grounds 4 and 5, the Human Rights Act point. Those are the structure of my submissions. So if I may start then, please, by taking a broad look at the Equality Act.
Do you want to say anything about the functions performed by the Equality Act and the Human Rights Act as seen in this case?
My Lord, I was going to pick that point up as I went along, but I'm
yes, all right. Well, just give us a high-level view of what you're going to tell us about that.
In respect of the question of whether or not Cornerstone is acting compatibly with the Equality Act and the Human Rights Act in respect of Article 14, in my submission, the application of either doesn't lead to a different answer.
I'm sorry, there's quite a lot of background noise. Could you just say that a bit louder?
So insofar as we're looking at the Equality Act application and the Human Rights Act application to Cornerstone itself, so that's the point that comes up under ground 4 and the point that comes up under grounds 2 and 3. The application of either legislative regime leads to the same outcome in this case. And my submission is that in almost all cases, that will probably be the position. I wouldn't want to rule out the possibility that one might get a theoretical case where one gets to different results on the application of each act. But it would ordinarily be the case that if one was applying a proportionality test under the Equality Act and applying a proportionality test under the Human Rights Act, one would get to the same place. And indeed, I don't think it's necessary to take the court through it, but there's certainly authority under, say, for example, Section 19 of the Equality Act, which starts to bring proportionality analysis under Section 19, brings it in line effectively with the Human Rights Act analysis, particularly where it's being applied under Section 29 to the exercise of provision of goods or services or the exercise of public function. In other words, there's a morphing in effect of the test to be applied, and that's broadly, as Mr. O'Neill said to you yesterday, the Bank-Mellon test.
Thank you.
So in terms of the Equality Act, it may assist the court to turn up the index to the Act, which I've inserted at tab 1 of the supplemental bundle of authorities. It starts at page 2. And the way that the Act works is as follows. Part 2 of the Act Chapter 1 sets out the protected characteristics, in other words, the characteristics on which discrimination will not be permitted. Chapter 2 of Part 2 then defines discrimination. So one can see at the top of page 3, direct discrimination and indirect discrimination at section 19. Those are sort of vaguely abstract concepts, because what the Act then does is apply those definitions in particular contexts. So it says in particular contexts, discrimination on the grounds of protected characteristics will be unlawful. And then you can see those contexts set out, Part 3, services and public functions, Part 4, the bottom of page 3, premises, Part 5, work, page 4, and education, and so on. So when one reads Part 2 with Part 3, as I'll go on to explain a little bit more detail in a moment, the starting point is that sexual orientation discrimination, the provision of goods and services is unlawful. And that applies to religious organisations who operate in any of the contexts specified in the Act, as much as it applies to any other organisation. The Act then goes on to set out exemptions from what would otherwise be unlawful discrimination. Some of those are specific to particular contexts. So, for example, there are education-specific exemptions, single-sex schools, religious schools, where admission on the grounds of sex or admission on the grounds of religion is exempt from the general principles of non-discrimination. Some are general exemptions and may apply across a range of contexts. That's important because the Equality Act does give religious organisations special treatment in the Act. And that includes special treatment in the context of sexual orientation discrimination. But the special treatment, when I say special treatment, I mean shorthand for an exemption, it is applied via exemptions. It's not applied by a manipulation or stretching of the meaning of discrimination. And the burden is on the religious organisation to show that an exemption applies to it. But it should be exempted from the starting point, which is that discrimination on the grounds of sexual orientation is unlawful. Now, those special provisions for religious organisations are very subtle and they're quite nuanced. They apply different tests. Some of them apply a test of proportionality. Some of them apply what I would describe as a threshold test. Do you meet various criteria? And a slightly lower standard in effect than a proportionality, or a less exacting standard than a proportionality test. And which applies, Parliament's been quite deliberate, it depends on the context, depends on the kind of organisation, and it depends on the type of discrimination that's concerned. Can I just give you some very high-level examples? I don't need you to turn them up, but just to give you a flavour of it. So that Schedule 3, for example, paragraphs 25A and 25AA, and that provides exemptions from Part 3, which is services and public functions. That provides an exemption for religious organisations who do not wish to conduct same-sex marriages or civil partnerships. The reference for your note is Authorities, tab 4, page 77. Similarly, there are exemptions in the context of work. That's in Schedule 9, so that organised religion can discriminate on the basis of who it employs, where threshold criteria are met, or if you have an organisation with a religious ethos, you can discriminate against somebody on the basis when you employ them, but only if you show you meet the proportionality threshold. So a difference between organised religion on the one hand and a religious organisation on the other. That's paras 2 and 3 of Schedule 9, and the note, the reference for your note is Authorities tab 4, page 80 to 82. Similarly, in Schedule 11, which concerns
When
education,
you're giving us these authorities, tab 4, 80 to 82, which bundle are we in?
that's in the first authorities bundle.
In the main authorities
Yes,
bundle.
sorry.
Thank you.
Apologies, I wasn't clear about that. Which
And that was Schedule 9, Para 2.
Para 2 and 3. 2 is the purposes of organised religion. 3 is for the purpose it's a person who has a religious ethos. And similarly, Schedule 11, which gives exemptions from the education provisions, you have an exemption for admissions to religious schools. Then the page reference for that is pages 23 to 25. So that brings me on to Schedule 23, which was, of course, the exemption that Cornerstone, in this case, applied to it in respect of its sexual orientation, which it was conceded below that did apply in respect of discrimination on the grounds of religion or belief. Can I just ask the court to turn that up? That's in the first bundle of authorities. Tab 4. Tab 4, page 83. And this sets out an exemption for organisations related to religion or belief. And just if I may draw a number of points to your attention. First of all, it applies to an organisation, the purpose of which is to practice a religion or belief, advance religion or belief, teach the practice or principles of religion or belief, or enable persons of religion or belief to receive any benefit, foster or maintain good relations. So it's an extremely wide definition of a religious organisation. Then, in paragraph 3, sets out the activities that are covered. And again, the court may note that those are an extremely broad set of activities. There is then a different approach taken depending on whether the characteristic on which a restriction is imposed is sexual orientation or religion. So religion, the test is at subparagraph 6.
So just go a little more slowly.
I'm so sorry. I was setting, I think, taking it back a step. I've taken you to subparagraph 3, which sets out the
Yes.
activities. And my submission was that was an extremely broad range of activities that an organisation may carry out.
Yes.
I've skipped over 4 and 5 because 4 simply refers to a person as opposed to an organisation. 5 refers to a minister. I don't think those need to delay us. But 6 sets out the threshold requirements that a religious organisation must meet if it wishes to impose a restriction in respect of any of those activities in the context of religion or belief. And you can see over the page 84, because of the purpose of the organisation or to avoid causing offence on the grounds of the religion or belief to which the organisation relates to persons of that religion or belief. At 7, a different threshold test is imposed in relation to sexual orientation. Slightly differently worded, because it is necessary to comply with the doctrine of the organisation or to avoid conflict with strongly held convictions within subparagraph 9. And then there's a definition you'll see at subparagraph 9 of what strongly held convictions might be. Just pausing there for a moment, it's an extremely widely worded provision. It applies a threshold test, not a proportionality test, and it treats religion and sexual orientation differently. Now, Cornerstone didn't bring itself within these provisions in respect of its restrictions concerning sexual orientation because of subparagraph 10. And you'll see that the paragraph doesn't permit anything which is prohibited by section 29, so far as relating to sexual orientation, if it's done on behalf of a public authority and under the terms of a contract between the organisation and public authority. And so what the provision contemplates is that even when a religious organisation acts on behalf of a public authority or under the terms of the contract, Parliament has accepted that the religious organisation may apply restrictions in relation to religion or belief, so that it may not apply those restrictions in respect of sexual orientation.
And that is 10.
That's 10.
Yeah.
And that's a quite clear policy choice by Parliament. Now, the application of that provision, whether or not the judge was right in his conclusion that that provision applied to Cornerstone is not the subject of appeal because permission to appeal was not granted.
And that's when, in fact, he went through the process of looking at 10A and 10B and making the determinations
That's right.
of fact,
That's
which
right.
hadn't been challenged.
An application was made for permission to appeal. Permission to appeal was
Was
not
refused.
granted.
I'm sorry, I didn't hear that interchange. Could you just tell me again?
My lady asked me whether that was it, that it was in respect of subparagraph 10 that the judge went through both A and B, made findings of fact below that the provision applied, and that although that was subject of an application for permission to appeal,
Was
permission
refused.
was not granted.
Yeah, thank you.
My ladies, the other exemption, of course, is section 193, which is, again, special provision that's being made by Parliament in respect of charities. You have been taken to that, but may I just make a submission in respect of one point that Mr O'Neill made yesterday, and that is, it's 193 is on page 73, the section that you're already in. And the submission was made that that is an exemption for the entirety of the Act, looking at the words, a person does not contravene this Act. I don't have any dispute with that, save that the case must be made in respect of each protected characteristic. And that submission is, that submission is well founded, can be seen from the remainder of subsection 1, only by restricting the provision of persons to persons who share a protected characteristic. So even insofar as a charity wishes to restrict the provision of benefits to people who share protected characteristics such as sexual orientation, the charity must show that that is either within 2A or within 2B. And similarly, the same process must be gone through in respect of religion or belief. It isn't a free-for-all on all of the protected characteristics once you're in respect of one.
So you are saying, give me, I just want to get this clear in
Yes.
my mind. You are saying, in respect of subsection 2, that is the provision which identifies the fact that it has to be in respect of each, that the test has to be carried out.
No, I'm so sorry. It's subsection 1, because if one follows the language through to the end, restriction of benefits to persons who share a protected characteristic.
Yeah.
So the focus is in on the specific protected characteristic that the persons share,
Yeah.
to whom the restriction of benefits is being applied. So if I'm a charitable organisation who only wishes to provide my benefits to women, for example, I would then have to justify that criteria by reference to subsection 2. If I also wanted to restrict that to, for example, gay women, I would have to do a similar process in respect to the additional protected characteristic that was being applied. And can I just make one point on this? I think it's perhaps obvious, but I think it's worth making again. In subsection 2, there are 2 different tests applied. And that reflects policy choice as to how difficult or how easy Parliament wants to make it to restrict those particular benefits.
So within 1932, you have in case A a proportionality test, and in case B a threshold,
Exactly.
or a condition, depending on
Exactly. And so Parliament has obviously deliberately chosen that in circumstances where you're restricting provision of benefits in order to compensate for a disadvantage, it's effectively a kind of positive discrimination clause, and it's a threshold test. You don't need to show, as we saw in Z, that there's no requirement to meet an additional test of proportionality.
Right. Well, now, you may not have finished this very helpful passage, but if we were just to step back at this point, you've taken us through the Schedule 3 process, which you say, because of the court's findings and the absence of permission to appeal, takes Cornerstone nowhere.
I need to be a little bit precise about that, my lord. And I'm going to come on to this in a moment, but direct discrimination cannot be justified. So if one is within the clutches of Section 13.1, it's favourable treatment because of a protected characteristic, then unless the alleged discriminator can show that an exemption applies, it's game over, as it were. Indirect discrimination is a little bit more complicated because also indirect discrimination has a built-in justification requirement.
So, as to direct discrimination, then your analysis through these provisions is that the exemption cannot assist.
Well, there's no unappealed.
Yes, well, that's the end result, is that.
Yes, because just to be entirely clear, there is no full frontal appeal on the Section 193 findings of the judge below. There's a collateral attack in the sense that it would never have been something that Ofsted looked at in the first place.
Yes.
There isn't a front-on attack to the 193 findings.
But that's through Schedule 3. You've then taken us to through Section 193, the charities aspect of this, where the outcome might be different because of the application of proportionality.
Can I take a step back?
Yes.
So the first question must be, is there direct discrimination at all,
Yes.
or indirect discrimination? If there is either, there may in any event be paragraph 2 of Schedule 23 may come to the rescue, point 1, or alternatively, because Cornerstone is both a religious organisation and a charity.
Wait a second.
Sorry, I'm
I'm
going
trying
too
to take
fast.
this down. So if there's either paragraph 23.
Shall I start again?
Yes.
Yes, please.
So the first question is whether or not there is direct discrimination or indirect discrimination on the grounds of sexual orientation.
Yes.
If there is, because Cornerstone is both a religious organisation and a charity, it may find itself exempt under paragraph 2 of Schedule 23, or it may find itself exempt under Section 193.
Yes. So I may have misspoken in describing these earlier on. So there are two inquiries that have to be carried out.
Carried out below, yes.
Because of the religious status and because of the charitable status. Those may, at least theoretically, lead to different outcomes.
Yes, because they've got very different tests, and
Yes.
even within paragraph 2 of Schedule 23, you've got different diversion for sexual orientation and religion, particularly in respect of subparagraph 10.
Right, thank you.
Before I continue, may I ask for a moment just to sort out my bundle collapse that's just happened? Because I think it may be quicker and easier for all of us if I sort it out rather than trying to keep all the
Yes.
thumb in the place. But would you mind rising for a moment? Thank you very much.
Would you like us to rise?
I can do it in front of you if you're happy to.
We're
I don't think
perfectly
it'll take
happy
very
to
long.
stay,
I'm just going to
stay
switch
where we are.
folders.
Thank you.
Thank you.
We won't watch.
It's always the
We
way.
might
isn't
come
it?
and help. Thank you. I'm very grateful. So, my ladies, just taking the Equality Act as a whole, my final point really, just to draw it all together, so one can see that Parliament has struck extremely careful balance between the rights of religious organisations on the one hand and the rights of others, where the manifestation of those religious rights might conflict with the rights of others. And as you've seen, the balance that to be struck will depend on the context, depend on the kind of discrimination, and it will depend on the threshold test that's to be applied. I said at the beginning I intend to focus in particular on two particular aspects of the Equality Act. First of all, sexual orientation and the definition of it, and second, direct discrimination. May I start with sexual orientation? I'm very sorry that the provisions of the Act are split over the supplemental bundle and the main. I'm sorry about that, but the definition of sexual orientation is in the supplemental parts of the authority bundle that tab 1. It's section 12, which is at page 17. And subsection 1 defines sexual orientation as meaning a person's sexual orientation towards persons of the same sex, persons of the opposite sex, or persons of either sex. And then subsection 2 goes on to define the protected characteristic of sexual orientation simply by saying that in reference to a person who has a particular protected characteristic is reference to a person who has a particular sexual orientation and so on. In my submission, sexual orientation towards, i.e. the opening words of subsection 1, plainly includes the manifestation of that sexual orientation by way of sexual behaviour. Were it otherwise, the protection of section 12 would really be no protection at all for lesbian and gay people. But in any event, there is case law confirming that submission to be correct. And that is a decision in amicus, which is tab 13 of the bundle of authorities. Which is a decision of Mr Justice Richards. It's back in 2004. And the context of this case was that it was a challenge by claimant trade unions to the implementation of an EU directive conferring protection in the context of employment and vocational training for sexual orientation. And it was a challenge to the regulations implementing that EU directive on the basis that it hadn't been properly implemented. It was pretty much a belt and braces attack. But the focus for our purpose is the exception contained in Regulation 7, which is set out at paragraph 14, internal page 1185. Lord, I'm so sorry, I know you're following along the electronic bundle. For some reason, my page numbers in this section of my authority bundle have vanished. I'm not sure if that's going to be a problem.
1185 in the report itself.
That's right, Lord, yes. It's paragraph 14, if that's an easier way for you to find it.
Yes.
And this was the particular exception that was one of the challenges raised by the claimant unions. And in particular, Regulation 7.3 is in the context of exception for genuine occupational requirements. And subparagraph 3 provides that the paragraph applies where the employment is for the purposes of an organised religion and the employer applies a requirement related to sexual orientation so as to comply with doctrines of religion and so on. The focus for these purposes is on the words applies a requirement related to sexual orientation and what that meant in practice.
So these are forerunner regulations to the Equality Act.
That's right. There was various piecemeal bits of pieces of regulation through the 2000s concerning sexual orientation, mostly implementing various EU directives.
Yes.
And the point is picked up at paragraph 119, which is page 1211, internal report numbering.
Yes.
And here the judge considers what does a requirement related to sexual orientation mean. And he notes the words may in one way make the requirement provision wider in scope than Regulation 7.2, where the relevant occupational requirement is expressed in terms of being of a particular sexual orientation. I note that the choice of wording in Regulation 7.3 was deliberate so as to accommodate the concerns of some churches about certain forms of sexual behaviour rather than sexuality as such. In my view, the wording is apt to cover the point, and it may have been prudent to use such words to avoid argument about the scope of the expression being of a particular sexual orientation. And he goes on to say, the protection against discrimination on grounds of sexual orientation relates as much to the manifestation of that orientation in the form of sexual behaviour as it does to sexuality as such.
Well, the wording is not the same.
No, it isn't the same, but it's obviously we're because of rather than a requirement related to. I accept that the wording isn't precise, but certainly in that context, the judge took the view that the expression was wide enough to catch sexual behaviour. To be entirely clear, my submission is that's abundantly clear from an interpretation of Section 12 of the Equality Act, but this passage of this judgment provides support for that submission.
But the comparator which we've got in the Act is sexual orientation towards.
Yes. But it is sexual orientation towards, it's not orientation towards, and that, in my submission, must mean something. And it's plainly sufficiently wide to capture sexual behaviour. Now, direct discrimination. If I may ask you to turn up section 13, which is in the main provisions of the Equality Act, so in the original bundle at tab 4. Section 13, which is at page 65. Section 13.1, person A discriminates against another B if, because of a protected characteristic,
A treats B less favourably than A treats or would treat others. One can see from the remainder of that paragraph that there isn't any provision justifying direct discrimination. But in deciding whether a person A has treated B less favourably than he treats or treats others, and looking at the treatment of the others, section 23 is relevant. That's on page 67. And subsection 1, on a comparison of cases for the purposes of section 13, 14 hasn't been brought into effect, or 19, that's indirect discrimination, there must be no material difference between the circumstances related to each case. So in other words, when you're comparing the treatment of B and others, they must be in materially similar circumstances. Very importantly, for the facts of this case, subsection 4, if the protected characteristic is sexual orientation, the fact that one person, whether or not the person referred to as B, is married to a person of the same sex, while another is married to a person of the opposite sex, is not a material difference between the circumstances relating to each case.
So that was the Predian Bull situation.
Yes, it's a slight tweak on the Predian Bull, because of course in Predian Bull the comparison was between heterosexual married and same-sex civil partnership. Here, the provision is making clear that if it's heterosexual marriage, same-sex marriage, that's not a material difference for the purposes of the comparison. Now, there's been a substantial amount of case law on how one answers the reason why. So, why is B treated less favourably than others? And in my submission, there are 3 relevant propositions of law that one can derive from the cases, and I'll take you to 2 Supreme Court cases in a moment to make these 3 propositions good. But the first is that in determining whether less favourable treatment is on the grounds of a protected characteristic, court's focus must be on the factual criteria that determine the decision made by the alleged discriminator. What were the factual criteria applied? The motive...
Sorry, can you just...
Yes, of course.
Can I just have the last bit after factual criteria?
Factual criteria that determine the decision made by the alleged discriminator. The motive for applying that factual criteria is irrelevant. Just want to give you a quick example to contextualise that, but I will come back to that in the context of the 2 cases that I intend to show you. So a good example of that is in the case of Al-Hijra. I don't need you to turn it up, just for your note, it's at Authorities Bundle 22. And that was a case in which the school segregated girls and boys in a mixed-sex school, lessons, non-structured time, and so on. And so the difference in treatment was sex, and the factual criterion applied to treat one group in one way and one group in another way was sex. The reason for that treatment was religion or the preference of the parents, but that motivation was not relevant. That was still direct sex discrimination. And that motivation is irrelevant, as I will show the court in a moment, even when, as Cornerstone contend, being of a particular protected characteristic is seen by the religious organisation as a criterion of membership of that religion.
I'm sorry, I was still on Al-Hijra. So the girls and boys were segregated on the grounds of sex. The motivation was religious, but that was irrelevant.
Yes.
And then you went on, and I'm sorry.
Yes, I'm so sorry. What I was going to say is that motivation is still irrelevant, even if, as on the facts of this case, the being of a particular protected characteristic, heterosexual, or not engaging in same-sex sexual activity, is seen by the religious organisation itself as being a criterion of membership of the religion. That doesn't make the case any better. Point, it's still a motivation. Now, I will make that point good in a moment.
I just wanted to unpick that sentence. Now we've got it all. It's not being of a protected characteristic. It's having a certain characteristic. It's seen as being.
Well, I will circle back to whether or not we are talking here about a protected characteristic or having a characteristic. And certainly, all that the Equality Act is concerned about is discrimination on the grounds of protected characteristics. It isn't interested if a criteria of membership of the organisation is baptism, for example, unless baptism is proxy for some other protected characteristic.
Or being red-headed,
Indeed.
unless it's actually
Unless it's an ethnic
race,
characteristic,
ethnicity.
for example. So religious organisations can apply any criteria for membership they wish, but if that is a protected characteristic, and not just that, but if it is applied in a context with which the Equality Act is concerned, so goods and services, education, work, etc., then that may be direct or indirect discrimination, may fall to be either justified or subject to an exemption. Shall I leave that there for a moment and perhaps illustrate that a little further by way of the two cases? Or
Yes, go on, please.
the second point, which I think to a large extent has been shown by by section 23, is that discrimination between a heterosexual married couple and a same-sex married couple will be direct discrimination on the grounds of sexual orientation. And the third point, which picks up to a certain extent my Lord's point about what's the characteristics being applied. If the criterion applied is not on its face a protected characteristic, but is in fact indissociable from a protected characteristic, that will also be direct discrimination.
Please, would you say that again? I'm sorry.
If the criterion applied is not on its face a protected characteristic, but is in fact indissociable from a protected characteristic, that will also be direct discrimination. And just to flag where I'm going on that, a prohibition on same-sex conduct, if that is not sexual orientation, which I say it is undoubtedly indissociable from sexual orientation. So, I say two...
And the judge found that.
Indeed. Two Supreme Court cases collectively make good those points. The first is JFS, which is Authorities Bundle Tab 29. Supreme Court in 2009. So this was a case concerning the admissions criteria of JFS, which gave priority to children who were recognised as Jewish by the Office of the Chief Rabbi. That recognition was based on matrilineal descent or conversion in accordance with the tenets of Orthodox Judaism. So, like here, there's no question in this case but that the school was permitted to apply a religious admissions criteria, because it was a religious school, so it would be caught by the exemptions to education provisions. So as here, as Cornerstone is a religious organisation and allowed to discriminate on the grounds of religion. And also, like here, matrilineal descent was said to be a criterion for being a member of Jewish faith. Sorry, just matrilineal descent was said to be a criterion for membership of the Jewish faith. Terrain on which the argument was fought was whether this was direct or indirect race discrimination. Of course, the important point being that direct discrimination cannot be justified, indirect discrimination can be. A majority of the Supreme Court held that it was direct race discrimination.
5-4.
Sorry?
5-4.
Yes. Yes. So Lord Phillips, you can pick the analysis up there at paragraph 13. And perhaps just for context, it may be sensible just to look up a couple of paragraphs above to paragraph 11, because this was a case under the Race Relations Act, and the wording was a little different to the words that appear in the Equality Act, so on racial grounds he treats, as opposed to because of in section 13. In paragraph 13, in the phrase grounds for discrimination, the word grounds is ambiguous. It can mean the motive for taking the decision or the factual criteria applied by the discriminator in reaching his decision. In the context of the 1976 Act, grounds has the latter meaning. In deciding what were the grounds for discrimination, it is necessary to address simply the question of the factual criteria that determined the decision made by the discriminator. And then he goes on to set out passages from House of Lords' decision in Birmingham, and sets out a passage of from Lord Goffert, D to E on that page, and notes that there is discrimination under the statute, there's less favourable treatment on the grounds of sex. In other words, if the relevant girl or girls would have received the same treatment as the boys but for their sex. The intentional motive of the defendant to discriminate, though it may be relevant so far as remedies are concerned, is not a necessary condition of liability. And he goes on at E to note, indeed, as Mr Lester pointed out in the course of his argument, if the council's submission were correct, it would be a good defence for an employer to show that he discriminated against women not because he intended to do so, but, for example, because of customer preference or to save money, or even to avoid controversy. Paragraph 14, Lord Philip then goes on to look at the decision of the House of Lords in James and Eastleigh. And that was a case in which sex discrimination was an issue. The council discriminated between men and women aged between 60 and 65 in relation to the terms on which they were admitted to swim in a leisure centre run by the council. And the motive for the discrimination was an application of pensionable, the criteria of pensionable age. In other words, those who were of pensionable age were permitted to go free, those who were not of pensionable age had to pay. The difficulty was that at the time, pensionable age for men was 65, but for women was 60. And the question was that direct sex discrimination? Over the page, the Court of Appeal held that the motive, i.e. the desire to treat people who are pensionable age more preferably was the motive, was the reason for the difference in treatment. And that was held to be wrong by the House of Lords. See Lord Bridges' reasoning is set out by Lord Phillips at the top of paragraph 15. And Lord Phillips picks the analysis up at letter E, where he says the but-for test, i.e. but-for sex, was another way of identifying the factual criterion that was applied by the council as the basis for their discrimination, but it's not one that I find helpful. It's better to ask, what were the facts that the discriminator considered to be determinative when making the relevant decision? At 20, third paragraph, just above letter C, whether there has been discrimination on the grounds of sex or race depends on whether sex or race was the criterion applied as the basis for discrimination. The motive for discriminating according to that criterion is not relevant. There is then some discussion at paragraph 34 and on page 844 as to whether being of matrilineal descent is a religious test or whether it's a test of ethnicity. And the court goes on at paragraph 35 to note that JFS say that the test is applied, the test for determining who is a Jew is laid down by orthodox Jewish religious law. Again, the court says what subjectively motivates them is compliance with religious law, not the ethnicity of the candidates who wish to enter the school. My reaction to this argument will already be clear. It is invalid because it focuses on a matter that is irrelevant, the motive of the discriminator for applying the discriminatory criteria. And then at paragraph 36,
and that last sentence at the top of the following page at the end of paragraph 35 is relevant, isn't it?
Yes.
A person who discriminates on the ground of race, as defined by the Act, cannot pray in aid of the fact that the ground of discrimination is one mandated by his religion.
Indeed. And then similar points are made by Baroness Hale at paragraph 65 on page 853. And starting at the second sentence, she notes there's absolutely no doubt about why the school acted as it did. We do not have to ask whether they were consciously or unconsciously treating some people who saw themselves as Jewish less favourably than others. Everything was totally conscious and totally transparent. M was rejected because he was not considered to be Jewish according to the criteria adopted by the Office of the Chief Rabbi. And then she goes on to say that if the criteria he adopted was, as in the Birmingham case or the James case, in reality ethnicity-based, it matters not whether he was adopting it because of a sincerely held religious belief. No one doubts he's honestly and sincerely trying to do what he believes that his religion demands of him. And finally, Lilcar at page 875, paragraphs 119 to 120. Paragraph 119, he says, all Jews define membership of their religion by reference to descent or conversion. It's therefore quite logical to describe the decision taken as a matter of Jewish law as to whether one is or is not a Jew as a religious one. Descent is employed as a means of determining an essentially religious question, but when the answer to that religious question has consequences in the civil law sphere, its legality falls to be examined. If the decision has consequences that are not permitted under the law, the fact that it was taken for a religious purpose will not save it from the condition of illegality. In this case, the OCR decision that M was not a Jew had profound consequences for him since he was denied admission to an educational establishment that he wished to attend. The fact that the decision not to admit him was based on the determination of a religious issue cannot, of itself, insulate it from the charge of discrimination on racial grounds. Once it is recognised that M's ethnic origins underpin the conclusion on a religious issue, it becomes plain that it cannot be characterised as an exclusively religious question. The terminus for OCR was a decision on a matter of religion. The route to that terminus was one of ethnic origin. So in my submission, that case is authority both for the proposition that the motivation for distinguishing on the grounds of a protected characteristic is irrelevant, even if that's a benign motivation. It's also authority in my submission for the proposition that where a protected characteristic is applied as a criteria for membership of a religion, that's no better an argument. Still questioning motivation. Now, the second authority is Preddy, which is, the court has been taken to already, but I wanted to take the court to some additional passages if I may. It's tab 36, just over the page. And the facts were rehearsed by Mr O'Neill yesterday. I'm not going to repeat them. But it is worth focusing in on the argument run by the appellants at paragraph 17. The argument that Mr and Mrs Stapleton did not discriminate against Mr Preddy and Mr Hall on the grounds of their sexual orientation, on the ground they were not married to one another. They've applied exactly the same policy to unmarried sex couples. So that's the argument that was being run. The question in this section of the judgment is whether or not that's direct or indirect discrimination. At paragraph 18, Baroness Hale refers to the decision in James and Eastleigh. It was referred to by Lord Phillips in JFS. And she noted that in that case...
Where are we now?
Paragraph 18, my lord. So sorry,
yes.
Letter B specifically.
Yes.
All women reached that age at 60, while all men reached it at 65. There is thus an exact correspondence between the criterion and the protected characteristic of sex. So the point being here that even if stated reason is not related to sexual orientation, so not related to a protected characteristic, if it is in fact indissociable from a protected characteristic because of a precise match between here, sex, and ability to comply with the criterion, then that will also be direct discrimination. And she goes on to explain that in a little bit more detail. She cites at paragraph 19 the words of Advocate General Sharpton, who said, I take there to be direct discrimination when the category of those receiving a certain advantage and the category of those suffering a correlative disadvantage coincide exactly with the respective categories of persons, distinguished only by applying prohibited classification. And then she notes here, so paragraph 21, applying that test, there isn't an exact correspondence between those suffering the disadvantage of being denied a double bed and those enjoying the correlative advantage of being allowed one with the protected characteristics. Which is, while all same-sex couples were denied, so too were some opposite-sex couples. At para 23, she again notes, this is at letter B, there's not an exact correspondence between the disadvantage and the protected characteristic. And she notes Lord Dyson's view in the Court of Appeal in Black and Wilkinson, which was the other case you'll recall Mr O'Neill referred to there being a second case, that was the other case. That in his view it was not a case of direct discrimination against a homosexual couple on the grounds of their sexual orientation, since there were other unmarried couples who would also be denied accommodation on the grounds that they too were unmarried. And she goes on to say at paragraph 24, were this case solely about discrimination against the unmarried, I would agree with him. And she made reference to the Rodriguez case that Mr O'Neill took you to yesterday. And then at paragraph 25, she said, does it make a difference that this couple was in a civil partnership? In my view, it does. And the reason for that, at 26, is that though civil partnership is not called marriage, in almost every other respect it's indistinguishable from the status of marriage, and goes on to provide further detail about that. But she then concludes at 29, which is on page 926, at letter E, by saying, I have the greatest difficulty in seeing how discriminating between a married and a civilly partnered person can be anything other than direct discrimination on the grounds of sexual orientation. And she goes on a little further down to say, I would therefore regard the criteria of marriage or civil partnership as indissociable from the sexual orientation of those who qualify to enter it. And more importantly, there's an exact correspondence between the advantage conferred and the disadvantage imposed in allowing a double bed to one and denying it to another. So that then results in her conclusion that the treatment here amounted to direct discrimination and not indirect discrimination. She then went on to consider, though, the alternative, what if it was indirect discrimination. I do just pick this point up while we're here because it has resonance in this case. And picking the point up at paragraph 34, Mr and Mrs Bull argued they should not be compelled to run their business in a way which conflicts with their deeply held religious beliefs. They should not be obligated to facilitate what they regard as sin, etc. And a fair balance should be struck between their right to manifest their faith and the right of Mr Preddy and Mr Bull to obtain goods, facilities and services, etc. And so when considering the justification aspect of section 19, the question was, can you balance the religious motivations of the appellants on the one hand with the rights of the gay couple not to be discriminated against on the other? And at paragraph 37, Baroness Hale says, well, you can't bring religious motivation back into the justification stage, because to permit someone to justify discrimination on the grounds that he did not believe that persons of homosexual orientation should be treated equally with persons of heterosexual orientation would be to create a class of people who are exempt from discrimination legislation. We do not normally allow people to behave in a way which the law prohibits because they disagree with the law, but to allow discrimination against persons of homosexual orientation, indeed of heterosexual orientation, because of a belief, however sincerely held and however based in a biblical text, be to do just that. And she notes at paragraph 39, Mr and Mrs Bull are, of course, free to manifest their religion in many other ways. So, just to step back from that for a moment, it's quite clear from Preddy and Bull in my submission that if you treat married heterosexual couples in one way, married same-sex couples in a different way, that will be direct discrimination on the grounds of sexual orientation. There's a subsidiary point which I'll return to when I consider indirect discrimination, that allowing religious motivation to come in at the justification stage risks allowing carte blanche in effect for discrimination on the grounds of sexual orientation. And that's the point that she makes at paragraph 37 and on. So that was a slightly lengthier than I had anticipated traverse across the Equality Act, but what that does mean is that my submissions now can be relatively short in respect of the grounds of appeal. So I turn now onto ground 2, which is direct discrimination. Submissions on this are set out in paragraphs 17 to 37 of our skeleton argument, but I can take this relatively shortly. What's the reason why question? So go back to Lord Phillips' analysis in JFS. What was the factual criterion applied by Cornerstone in its approach to prospective lesbian and gay foster carers? And there are really two possible ways of analysing this. The first is the way that the judge analysed it, finding which is unappealed, that in practice, Cornerstone only accepts applications to be approved as a foster carer from evangelical, heterosexual married couples. The judge's findings on that are at paragraphs 41 to 42 of his judgment. Same-sex couples cannot meet that test, and that is therefore direct discrimination on the grounds of sexual orientation. That the motivation is religious is irrelevant, JFS. That the sexual orientation... Sorry.
I used to do it at the bar, and I used to be told to slow down by judges.
Terrible. Get into a trot and keep going.
Right, just try again. That
Yes, of course.
motivation is religious.
Is irrelevant. See JFS. That being heterosexual, having a particular sexual orientation, is an entrance criterion for the religion in Cornerstone's view. It's not relevant. So, sorry, just to be clear, what I mean by that is Mr O'Neill's submission that you cannot be an evangelical Christian if you are a gay person who is an actively gay person, as opposed to a celibate gay person who renounces same-sex relations. And in my submission, that comes directly from JFS, and the analogy between the matrilineal descent requirement in JFS and that of sexual orientation in this case. And finally, that one is a Christian marriage, so defined by one is not, is irrelevant. See section 23.4, read both with JFS ready. Now, that's the way the judge analysed it, and that's not appealed. But I am going to deal with the way that Mr O'Neill analyses it for completeness, because I say you get to the same result in any event. He says it's behaviour, not orientation.
Sorry, Mr O'Neill says behaviour, not orientation. No.
Sorry, it's just a shorthand, but
And I'm sorry too, I think it's just that I'm on this side of the court and the air conditioner is quite noisy, so if you could keep your voice up,
of course.
Thank you.
I'm sorry, Melody.
So Mr O'Neill says it's a matter of behaviour and not orientation.
Yes, a matter of lifestyle and so on. There is an express prohibition on same-sex sexual conduct in the Code of Practice, paragraph 10. And that, in my submission, is indissociable from sexual orientation. So, even though it doesn't say no gay people, in practice, having a prohibition on same-sex sexual conduct means that is a criteria that is indissociable from that of sexual orientation. And again, that then is direct sexual orientation discrimination. And I repeat the points I've made on motivation. Nothing surprising about any of this, because although it's obviously for religious organisations to determine who is and who is not a member of their organisation, Officer doesn't take any query with that.
No, I'm not hearing you either.
I project my voice a little more. There's nothing surprising about any of that analysis, because although it is obviously for religious organisations to decide who is or who is not a member of their religion, when they seek to manifest their religion in one of the contexts to which the Equality Act applies, work, education, etc., and where the manifestation of that religion has an impact on the rights of others, then it will be caught by the Equality Act.
Who's it impacting on here?
Well, it's impacting on prospective foster carers who would wish to apply to Cornerstone to be foster carer.
And what evidence is there of any of those?
Well, my lord, 2 points. First of all, we are in the context of regulated activity. Ofsted is the regulator. Ofsted applies, I'm going to come on to this in a moment, but Ofsted is entitled to say that when you're conducting a regulating activity,
you must comply with various standards.
I understand you say, and point to authority, that you don't need a victim.
No.
For Ofsted's regulatory function. But you said that when Cornerstone manifests its religion and it impacts on the rights of others. So what do you mean by the latter?
My Lord, I'm so sorry. I'm talking at a slightly high level of abstraction. What I'm saying is it's not surprising that the Equality Act leads to the result that I have indicated, because the whole point of the Act, as I hope at some pains to explain at the outset, is that it seeks to balance the rights of religious organisations to manifest their religion with the occasions on which those might rub up against, in effect, the rights of other people. Now, Ofsted is entitled as a regulator to say the Equality Act must be complied with, and that discrimination in the approval or selection for approval of prospective foster carers is problematic from a regulatory perspective. It is entirely unsurprising. It doesn't have to seek out a victim in order for it to make that point. That's the point of regulation. It's entitled to look at a high level. It doesn't have to wait until the thing that it's concerned about happens. Well, just to be entirely clear, if we're in the context of indirect discrimination, that there hasn't been a stampede of people applying to Cornerstone who are lesbian and gay may well be a matter to put into the balance. But it is thoroughly irrelevant for indirect discrimination, for sort of direct discrimination.
Right. So we're still with ground 2 here.
Yes. And of course it may also be relevant when one's looking at the proportionality balance in section 193, looking at the exemption.
Right. So it may be different for indirect discrimination or section 193.
Well, I want to be quite clear. I don't say it means that it is or is not. It doesn't mean the exemption does or does not apply. There are balancing acts to be conducted.
It may be different.
It may be, well, no, again, I'm so sorry, Mother, I want to be quite precise. It would be a matter to put into the equation. It wouldn't necessarily tip the balance one way or the other. It would be one thing that one would look at when looking at the range of factors relied on by an organisation to justify what would otherwise be unlawful discrimination. So, the other point, of course, to make is that the finding that it's direct discrimination isn't the end of the inquiry. It wasn't the end of the inquiry below. It was open to Cornerstone to seek to bring itself within the exemptions that are both specific for religious organisations and specific for charities. And it didn't discharge that burden. And the final point on this is not a surprising conclusion theme, as it were, is that, of course, we are in the context, as is unappealed by the court below, of public function being carried out on behalf of a public authority pursuant to the terms of a contract. And you'll recall my submission a little earlier this morning that Parliament has made a policy choice that in those circumstances religious organisations should not be permitted to discriminate on the grounds of sexual orientation. So in summary, my submission on ground 2 is this is a utterly clear example of direct discrimination. None of the exemptions apply.
Because of the findings of fact by the judge.
Indeed, yes. And that the findings initially by Ofsted that this was direct discrimination and subsequently by the judge were not only correct, but were the only ones that were open to him on the facts. Turning, if I may, to indirect discrimination, ground 3. The same treatment cannot be direct and indirect discrimination. It is either or. So if I'm right on direct discrimination, this ground effectively falls away.
That's Lady Hale in Preddy, isn't it?
Correct.
Yeah.
Yes, madam. There doesn't seem to be any dispute that if indirect discrimination, that the recruitment policy in principle is capable of, gives rise to a disadvantage to those of a particular sexual orientation, as it's harder those of a particular sexual orientation, i.e. non-heterosexual, to comply with it, because of the express prohibition on same-sex conduct. So the only question really that arose for determination below was whether or not that disadvantage was justified. And in my submission, the decision of Mr Justice Knowles, as he then was in Catholic care, is really precisely on point as to how to approach justification on the facts of this case. So I can ask you to turn that up. It's Authorities tab 10. I'm conscious that Mr. Knowles went through it yesterday, but I'm only going to take you to those passages that you haven't seen. You were taken through the factual background yesterday. I just wanted to highlight one point, if I may, and that's paragraph 2, page 217, where the judge explains at letter F that potential adoptive same-sex parents were excluded from consideration under the particular practice, and that practice is said to be required for reasons of Roman Catholic religious doctrine. Homosexual couples have to be excluded from any adoption services provided under the auspices of the Roman Catholic Church. It does note the charity has been willing in the past to consider adopted parents from other denominations and other faiths, but provided they would constitute a Nazarene family. Paragraph 15 starts on page 220. It's in the course of the judge's summary of the first-tier tribunal's decision. Just over the page at page 221, between letters B and C, the charity accepts that religious conviction alone could not in law provide a justification for the denial of its adoption services to same-sex couples. And I pause there to note, of course, that was by a concession, but that concession is entirely consistent with the comments of Baroness Hale in Preddy that I've already taken you to. Rather, the charity argues that discrimination proposed proportionate to the achievement of the legitimate aim it identifies because the discrimination would take the form of the denial of services which would not be available to same-sex couples from the charity, but would be available to them via other voluntary adoption agencies and local authorities. And also because if the charity permitted to discriminate, it would no longer be able to raise the voluntary income from its supporters and would have to close. So that was the justification of the legitimate aims relied on by Catholic care. Page 228, Mr Justice Knowles, as he then was, begins the analysis of the charity's grounds. First ground, you can see set out under the heading analysis, the charity's proposed mode of operation will be likely to assist children in need and hence is objectively justified. If I can just pick the analysis up at paragraph 47, which is on page 233. He notes that the legal context in which the charity comes before the tribunal is one in which the national authorities, in particular Parliament, have established a very clear framework of equality law which makes discrimination on grounds of sexual orientation unlawful. That is the basic ground rule of public policy established by the national authorities in their assessment of and responding to the needs of society. The charity seeks to rely on section 193, and he notes the remainder of that paragraph that the interest of promoting the traditional family in which the charity relies has not been endorsed by the national authorities, and that given that it doesn't obtain the same degree of weight as if it had been adopted by the national authorities as per Strasbourg judgments. But he goes on that
it doesn't really make much difference because, as he says at F, clear from Strasbourg authorities that even where a body acts in accordance with such views, if in doing so it discriminates against homosexuals, it is still necessary for it to show that there are particularly convincing and weighty reasons justifying differential treatment. And then at 50 he says, there can be no doubt that the interests of children in need is a very powerful consideration in the context of this analysis. So in other words, he accepts that in principle, the disadvantage caused to lesbian and gay men who wish to foster children via Catholic care could be outweighed, as it were, by the interests of children. And so at paragraph 52, picking up that thought, he says, if the charity were able to show that there is a significant prospect that more children will be placed into adoption if it is allowed to discriminate against homosexuals than would otherwise be the case, then the interests of the children who would be so placed provide an argument in favour of permitting the charity to proceed in that way. And he acknowledges the argument that if the charity was not allowed to discriminate against homosexuals, it would not mean that homosexuals can have access to its adoption services, but rather there'll be no adoption services provided by the charity for anyone, homosexual or otherwise, to have access to, and the children will lose out. And then he goes on to say that the 2 points.
I'm sorry, I've lost where you're reading from.
I'm sorry, my lord, I'm doing that.
It's all right, just give me the...
Racing ahead, I'm so sorry. I just finished paragraph 52 on page 235.
Yes.
And I was turning to paragraph 53.
Thank you.
And he says there are 2 points to emphasise. First, there's a big if in the charity's case, which requires careful scrutiny on the facts, to which I return below. And second, there is a significant difference between the position in this case and the position addressed in Re G. And he says, in Re G, the interests of children in need of being adopted were in line with and pointed to the same result as the general principle that discrimination on grounds of sexual orientation will not be objectively justified unless weighty and convincing grounds are put forward. In Re G, there was a total prohibition on unmarried couples of any sexual orientation being permitted to adopt in Northern Ireland. But he says here, there's an inherent conflict between the general interests of homosexuals and of society as a whole. There should not be discrimination on grounds of sexual orientation on the one hand, and on the other, the interests of children need to be placed with good adoptive parents wherever possible. And he says the burden on the charity to make out its case is accordingly greater than was the burden on the claimants in Re G.
What do you say to Mr O'Neill's general point about particularly weighty justification as against I've forgotten the adjective, scrutiny, when impinging upon religious freedoms?
Well, weighty, strict scrutiny, they're all the same way of saying much the same thing, which is you are to outweigh the harm caused by discrimination against gay people. You have to show compelling or particularly convincing reasons why that sexual orientation is justified. Now, as I've indicated, it may be, as Justice Sales indicated, that if there was evidence that this would cause the charity to close, and there was evidence that that would have significant impact.
I'm not talking here about the performance of the exercise. I'm talking about the criterion which one applies when embarking upon it. Is it your case that sexual orientation attracts a greater degree of protection than religious belief?
No, of course not.
So why are we concerned, in a sense, with...
We're concerned about it because we're looking through the lens of the Equality Act. And the Equality Act contains the balance that has been struck between religious freedoms on the one hand and the rights of lesbians and gay men not to be discriminated against on the other hand. It is no part of my learned friend's case that any bit of the Equality Act is contrary to Article 9. Now, it could have been. I could be that you might say that the balance struck in the Act doesn't faithfully reflect the balance in Article 9. But in my submission, that's not the argument Mr O'Neill is running. So this court, in my submission, can proceed on the basis
that the balance struck in the Equality Act is compliant with Article 9. Indeed, must do so.
Will this be the same when we get on to the later grant of appeal?
Well, that's right, because as I will say in due course in respect of ground 5, if Ofsted is right about the Equality Act, and the judge below is correct in the conclusions he reached, it would be a rather odd, extremely surprising, perhaps conventional outcome, if in applying the Equality Act to the facts of this case, correctly and in accordance with the law, Ofsted were found to have breached the Human Rights Act.
Yes, but this is a case in which the Equality Act has been found not to apply in relation to religious belief.
Yes.
So it's a rather peculiar
Well, it is, except
set of circumstances, whereas religious belief comes in again at ground 5.
I accept that, Michael, but that drives me back to my first point, which is, again, as I've hoped that I've been at some pains to be clear, that the Equality Act does treat religion and sexual orientation distinctly, and that the approach taken by Mr O'Neill is an attempt, in a way, to wrap sexual orientation requirements up into a religious
Well,
requirement.
one might equally say that the approach taken by Ofsted is an attempt to separate out the two in a case which involves them both indissociably.
Well, my Lord, if Ofsted has applied the Equality Act wrongly, well then that is, of course, will be the finding of the court. But in my submission, the Equality Act does treat the two differently. Ofsted has faithfully applied that distinction. It's either right or it's wrong. That's obviously a matter for the court. But what you can't do in my submission, absent a completely different case that Mr O'Neill is not running, is to say that the balance struck in the Equality Act doesn't faithfully reflect the requirements of Article 9. Because that's not the case he's running. He's never run that case. So, in my submission, the court must proceed on the assumption that applying the justification test as per Catholic care, as per, as I say, the requirements of the Equality Act, is compliant with Article 9. And the difficulty, just to push that point on a little bit further, the difficulty, of course, Mr O'Neill's case is that it's an attempt to bring religion back into justification. And that's problematic. See the concession, accepted a procedure on a concession in Catholic care. But that concession, as I say, is entirely consistent with the analysis of Baroness Hale in Preddy as to the inappropriateness of bringing in discriminatory criteria at the justification stage. I'm so sorry, I'm just picking up the case where I was in the case. I'm just a moment. Yes, in paragraph 55 of the judgment, at the bottom of page 235, the judge applies that analysis, i.e. the acceptance that you could in principle justify discrimination against lesbian and gay men. And perhaps if I can just ask you to read paragraph 55, because it's quite helpful in showing why on the facts of that case the justification wasn't met. And of course I don't say there's a read across, but what I do say is it's helpful showing the type of analysis and the type of threshold Mr Justice Knowles was looking for in the context of that case. And that, I say, is helpful when we look at the justification offered here.
Yes.
So overall, then, the argument based on section 193 was rejected by the tribunal on the basis that the proportionality test had not been discharged by the charity. I can ask the court then to pick up the reasoning by the judge, which in particular on this issue, which in particular starts at paragraph 188. I'm so sorry, I've foolishly taken the judgment out and I now can't read even remotely.
Right, give us paragraph numbers, we can
It's
work with those.
paragraph 188, it's 42 of the internal, the middle numbers. That's at all helpful.
188.
And it's 127 of the bundle.
Thank you. At 188, the judge sets out the legitimate aims relied on by Cornerstone. And then he goes on in the next few paragraphs to deal with the requirements of Catholic, or what was said in Catholic care. And then he picks up his own analysis again at paragraph 199. And then he says, key question, therefore, is whether the policy provides benefits to children and young persons, or whether, if it were changed as Ofsted required, that would produce a disbenefit, for example, by reducing the available number of foster carers. This requires consideration of the evidence that has been filed. And at 200, he considers, perhaps not in terms, but in reality, in this paragraph, he is looking at the first aim, increasing the pool of evangelical Christian foster carers, and the last aim, E, to increase the number of foster care placements available. And in that paragraph, he accepts Ofsted's evidence that there isn't any evidence that there is a shortage of evangelical Christian carers, in the sense, for example, that local authorities had a particular need for carers to be placed, for children to be placed with such carers, and were struggling to identify them. And the judge picks that point up a little bit further on in the judgment at para 207. This is in the context of talking about Cornerstone closing, but just it's a point that just follows on from what I've been saying. Last sentence, he says, there's no evidence a child would not have been fostered if Cornerstone did not exist. And just interpose to say that, with greatest respect to Cornerstone, the evidence before the court on this was extremely thin. That there wasn't any evidence from, for example, individual foster carers saying that they personally had become a foster carer because of the ethos of Cornerstone. There wasn't any evidence from a local authority, for example, saying that they had placed a particular child with Cornerstone that they had been otherwise unable to place, or that it would have taken longer, or would have been harder, or whatever. And there just wasn't any evidence that other independent fostering agencies who didn't apply the discriminatory criterion, that their approach was inadequate, or that those services couldn't find adequate numbers of foster carers for the children that needed them. And I make those points because that's really very similar to the position, the factual position that pertained in Catholic care, and the type of analysis that Mr Justice Knowles gave to the evidence that had been adduced in that case. The remaining three aims relied on by Cornerstone, so those are B, affording critical care to the carers, support to carers, allowing those within the evangelical Christian community to serve, and manifesting the beliefs of evangelical Christianity. These all had a religious element. In other words, they were all, in truth, a proxy for a desire, a justified and understood desire to manifest Cornerstone's religious beliefs and religious identity. But that takes us straight back into the difficulties of Preddy and the use of what are in truth discriminatory motivations at the justification stage. And I've taken the court to it already, but it's an important factor here to note that the judge said that there was no evidence that Cornerstone would close if it was required to make the changes that Ofsted had ordered. That's paragraph 207. And that's an extremely important factor in the proportionality balance. As I've set out with references in paragraph 42 of my skeleton argument, an appeal court ought not to disturb findings of a judge unless they are wrong when exercising a proportionality analysis. And in my submission, not only was the judge's approach on this not wrong, but it was also the only conclusion that he could have reached on the facts and on the state of the evidence for him.
Could we just examine your submission about the matters raised in 188 BCD, which you just touched upon, which are supporting carers and manifesting belief in practice by good works. You say those are impermissible aims?
No, my Lord, to be clear, if one takes them on their face, of course it's entirely permissible to have an aim of providing critical support. It's entirely permissible to have an aim of promoting stable and durable placements, and entirely permissible to have an aim to allow people or the community in general to serve. The difficulty in my submission comes when that is bound up inextricably with the manifestation of religious faith.
I don't understand that at all. I mean, some of the, I know nothing about the individual children who are fostered, but I know quite a lot about the sorts of children that need foster placements, and about the demands on foster carers, and about the predicament of foster carers who don't receive adequate support of the kind that this organisation says that it provides. And you provide some support for that understanding. I can perfectly understand an argument that none of these matters stack up. The judge didn't think they stacked up. But at the moment, I don't understand why you simply dismiss, for example, B, C, and D as being a proxy for Christian beliefs.
Well,
what if they are? It's clearly a situation in which people may gain in morale and strength by measures that seem to them to be good sources of nourishment of many kinds. So why are those not matters which could be taken into account in carrying out this proportionality exercise?
I think the difficulty, Lord, is where that leads to the conclusion in this case, that excludes a certain class. So we're in the situation now where we're justifying the exclusion of lesbian and gay men from, for example, the categories of support.
In this case, there are two particular features relevant to the discussion we're now having. One is that apparently for this organisation and those that work within it, carers, staff and so forth, the particular complexion of their religious belief sustains them in a way that is important to them and may have beneficial results for children if they're being looked after by well-supported carers. And the other aspect is, when we come to look at it in a moment, as I hope we will, the passages in which the judge posits the existence of gay evangelical Christians, in other words, the victims of this situation. But staying for the moment with the question that I've asked you, which is, why should B, C and D of paragraph 188 be regarded as impermissible?
Because it's by using religion, it's bringing the religious justification in at the justification stage. In
I
order
can understand
to explain,
I can understand that it doesn't do them any good to say it isn't discriminatory on your argument. But at the moment we're considering justification for discrimination, not existence of discrimination.
yes. Well, what I'm attempting to submit is that using religion as a justification stage, as a reason why those of a particular sexual orientation can be excluded is impermissible. And that was the explanation given by Baroness Hale in Preddy. So even insofar as the aims relied on are yoked onto the religious element in an exclusionary religious element, that's problematic for the reasons given by Baroness Hale in Preddy. You can't use religious motivation as a justification for not including gay people within your service. That's an exact copy of what Baroness Hale says in Preddy. Well, I can take you back to Preddy.
Yes, no, I have paragraph 37 well in mind.
And I'm grateful. I can't add any further to that. It's not the aims per se, it's the expression of the aims as being religious aims, with the implication being that that justifies the exclusion of those of a different sexual orientation.
Yes, all right. Now, at what point do you want to deal with the issues of the judge's reference to the Catholic caucus, paragraph 203, and by the same token, paragraph 208, where he refers to evangelical Christians who are in a same-sex marriage?
My Lord, yes, this is just, so sorry, I'm just picking up. But I really, as I understand the judge's reasoning on this point, it's simply to say that there are gay and lesbian people in all religious organisations. Now, maybe that those gay and lesbian people self-define
I
themselves.
can't hear you.
I'm so sorry. Maybe those lesbian and gay people define themselves as evangelical in a way that the claimant, the appellant, would not recognise. But that passage of the judge's reasoning is simply to make the point that there are individuals who would benefit from the types of services provided by Cornerstone, who are presently excluded from those services. That's all the judge is really saying there.
Well, what was the evidence? Is this judicial notice of this? Judicial notice that there are evangelical Christians in same-sex marriages?
Well, that there are lesbian and gay people in all religious denominations is, in my submission, a fairly obvious proposition. I'm afraid I do say that if I need to, that judicial notice may be taken of that. I accept that whether or not those individuals may meet particular criteria of this particular organisation's faith wasn't a matter that was reflected in the evidence below. But in my submission, it doesn't take the appellant any further. All that the judge is there doing is saying that there are individuals who are lesbian and gay who may wish to avail themselves of this service and would benefit from it. That's it.
Does he not need some evidence of that?
Well, that rather brings me back to the point, the discussion we were having earlier, which is about the question of whether or not there is a victim here. There has been one complaint, as you were taken to yesterday, and that was a broader complaint about religion or belief. But this is a case not about individual victims. This is a case about Ofsted discharging its regulatory obligations. And my submission, the judge was entitled to say that there may well be individuals out there who are lesbian and gay who would take
who could or may wish to avail themselves of this service. That's really the extent of my submission on those paragraphs.
Because that paragraph 203, the judge is actually, if one reads it as a whole, I think, saying, as you can see, about 5 or 6 lines up from the bottom, the number of gay and lesbian evangelical Christians is obviously not known. So to me, that is impliedly saying, I've got no evidence about this, obviously one couldn't tell, but I am assuming there must be.
Yes, well, and he goes on to say a little further on, it's a reasonable inference that, again, it's certainly the judge isn't proceeding on any suggestion that he's founded on evidence that's in the case. I accept that entirely. He's simply taking judicial notice of the fact that there are lesbian and gay men in all avenues or all different types and species of religion.
Well, is your submission, does it really amount to the fact that in conducting this exercise, the judge could still have been right, even if there were no identifiable victims, even if the evidence established that nobody was a victim of this discriminatory policy?
I do say that, and that's because there is Ofsted is entitled to conclude that there is a regulatory virtue in compliance with the Equality Act. And that regulatory virtue doesn't depend on there being individual victims.
So, how do you, in the end, deal with 203, 208 and so forth? That it's unnecessary to the judge's decision?
Yes, but he set out the aims. I've dealt with the first and the last. The 3 in the middle I've also dealt with, in the sense that those are religious motivations. And indeed, those passages, really the judge's decision would have been the same, even if one removed those paragraphs for the reason I've given.
This discussion is taking place in the context of us having got to the point where there's a proportionality exercise to be carried out at all. And I appreciate that we only get to that point after a certain number of prior steps. But as you can tell, I'm still having some difficulty in a proportionality exercise that proceeds on a basis, for example, could proceed on the basis simply of regulatory virtue and absence of identified victim or victim category in the context of a state of affairs that arises out of religious belief itself protected.
Well, that's no different to the exercise that was carried out by the Charity Commission in Catholic Care, or indeed by the Charity Commission here on the appellant's analysis. That is what regulators have to do. If they are applying a proportionality analysis, it's done in the absence of a complaint.
I understand that, but the proportion, I mean, it may be in the absence of a complaint, but one of the features of the proportionality exercise surely has to be to say, well, actually, we haven't got any complaints about this, that it's terribly discriminatory, and it is plainly discriminatory. But nevertheless, there are these factors which are suggested that justify it, and the factors that speak against it essentially boil down to the principle of the thing.
Yes.
Now, Ofsted would not be carrying out a proportionality exercise of any value if it simply said, well, there's the principle of the thing, because otherwise you didn't have a proportionality exercise at all.
Well, my lord, the difficulty with that submission, and my lord may be right, if Cornerstone had come along with convincing justification for why they're doing, why they apply the policy that they do, in the manner that I've just described, that explained why it is that this approach led, for example, for local authorities placing children with them that could not otherwise been placed, and so on, then that may well be.
But it isn't just about children who might have been placed or who might in future be placed. It's also centrally about the well-being of the children who are placed and the well-being of their carers, for whom this particular set of beliefs, in the case of the carers, is a matter of real importance.
Well, my lord, that's right, but
that, you say, has to be struck out.
It's not that it has to be struck out, but what Cornerstone is seeking to do by relying on this by way of the justification, you're bringing the discriminatory element back into the justification stage. You're saying that a religious requirement that excludes lesbian and gay people can form part of the justification for the exclusion of gay people in the first place.
Well, it may
and
be.
that, in my submission, simply can't.
I realise we have authority under which we act, but I'm just trying to bottom out the logic of this. It may indeed be an entirely inadequate justification, but I'm just at the moment examining the fact that it doesn't even get into the scales on one side at all on your analysis.
But that is because it's not because it's a religious justification necessarily. It's a religious justification that necessarily, on my friend's case, excludes gay people from its benefits. And so what is being sought to be done is, on the one hand, say, so there's a difference in treatment for gay people, and that can be justified by a reason which is in itself discriminatory. So you're counting the discrimination twice, in effect, both on one side of the equation and on the other, and that simply can't be right.
And the
that's really
obligation of the burden is on Cornerstone to
yes,
show the justification.
indeed.
So if in so doing they're seeking to rely on an impermissible justification, then that really does adjust the scales, as it were.
Well, technically, the justification falls out of, well, it's not a legitimate aim, in effect. It doesn't get into the scale in the first place.
So, yeah. So when I said adjust the scales, a clumsy way of putting it, but there's nothing there.
Well, there are the two that might, in principle, be legitimate aims, the first and the third, the final, and the three in the middle that, shorn of their purely religious motivation, may also be justification. But as I've said, the evidence before the court of the difference that the discrimination made in this case, as opposed to conducting the service without the discrimination, was extremely thin in my submission.
Again,
That's
that
the difficulty.
so sorry.
I'm sorry.
But going back to B, C, and D, what you're saying about them is, in fact, those are based on religion. The fact that it's based on religion isn't an impermissible thing in itself, but embedded in that religious belief, which is underpinning B, C, and D, is the discrimination against sexual orientation, and that makes them impermissible.
Yes.
C ready.
Yes. Exactly.
I'm sure that's what you've already said, but
No, that was a far more precise way, of a slightly struggled way in which I've been seeking to put the point, but that's precisely it.
Is this how the judge dealt with this? I'm looking at paragraph
Well, the judge,
2006, in which the judge appears to put it into the scales, but not, for reasons which may be very good ones, give it any weight.
I'm so sorry. No, I didn't catch
206.
the reference. 206.
I'd just like to follow through how the judge deals with B, C, and D in practice. He may touch upon it elsewhere, but he's certainly touching upon it there.
Well, he's saying the same thing in a slightly, except he's saying it in a slightly different way. I mean, in the first sentence, he's saying, firstly, how discriminatory policy positively impacts on Cornerstone's aim of affording critical care.
That's a factual finding.
No, I accept that. But he does then go on to say, my lord, at paragraph 210, again, makes the point that perhaps I've just made again in a slightly different way, and then refers to Preddy, paragraphs 37 to 38.
Yes.
And he does say, I'm so sorry, I'm just looking for the reference, he does say at one point, yes, paragraph 202, where he refers to there being insufficient evidence to show there are sufficiently weighty and just convincing reasons why Cornerstone should be permitted to have a policy which is at a minimum indirectly discriminatory, and the current policy is not sufficiently rationally catches the aims, and it also fails the third stage to achieve what it wants to achieve.
But what I see from that is that the judge is carrying out what you would say is a perfectly defensible, indeed right, proportionality exercise. What I'm jibbing at the moment, notwithstanding Preddy at 37, is that it simply doesn't get into the scales. I'm not sure when one looks at Preddy again, and you'll educate me about this, that that's actually what Preddy is saying. Preddy appears to be saying that the fact that you have these beliefs does not in itself amount to justification. That's not the same thing, to my mind, as saying you can forget it.
Maybe we're perhaps dancing on their head, because on the one, I mean,
no, I don't see this as the head of a pin at all. I see this as quite an important point.
You may analyse it as the aim is not a legitimate aim at all, or you may say that the aim is not rationally connected to the discriminatory policy, and those might, in truth, be very similar ways of saying the same thing. Either the aim that you're advancing has no, in truth, legitimacy, or it's not sufficiently rationally connected, so that you don't even get the balance at the end, because the aim that you're relying on simply skates past.
Well, why did the judge in that case not say, well, I'm not going to take time over B, C, and D because they're not permissible?
Well, but what he does say in 202 is it's not sufficiently rationally connected. So that is, in truth, a way of saying, another way really of saying that the aim pursued doesn't go to, doesn't explain the discriminatory policy pursued. Because, of course, you don't get to the balancing exercise until stage 4 of Bank Mellet.
Yes.
So whether you express it as it's not a legitimate aim or it's not rationally connected, one gets to the same place by submission. Because it's not something that goes into the balancing exercise, broadly speaking.
I didn't hear.
It's not something that goes into the balancing exercise.
So the fact that Cornerstone's carers gain sustenance from this is not to be taken into account.
Insofar as it's
Sorry?
Insofar as the sustenance comes from the religious beliefs, which are themselves exclusionary.
It's quite a stark submission, is it not? When one steps back and thinks about the position of people looking after
the
children.
difficulty is one can't separate the two things out, and that's the problem, because one can't separate out the religious sustenance that's being provided with my learned friend's submission that lesbian and gay people simply can't be included within the definition of that religion. So the difficulty I have, I'm afraid, and the reason why I'm putting it as high as I am, is that the religious sustenance that's being provided is itself discriminatory criteria. But we're back really to the same points that I've already made.
I understand what you're saying.
My ladies, unless I can provide any further assistance, those are my submissions on indirect discrimination.
Thank you.
I'm going to move on to ground 1, the Charity Commission. And I want to do 2 things, if I may. First of all, just deal with the role of Ofsted, first of all, and then second, just deal with the merits of the ground of appeal. Ofsted is the registration authority and also the inspectorate of independent fostering agencies. And those functions are set out in the Care Standards Act, which is Authorities tab 3.
Have you got a passage in your skeleton argument that you could usefully refer us to so that we can...
It's paras 7 to 16 set out the submissions. The legislation isn't really set out because of course it's contained to some extent.
All right. So the legislation in the Care Standards Act, tab, did you say 3?
Yeah, it's tab 3, my lord. And so no dispute that Cornerstone is an independent fostering agency for the purposes of section 4, subsection 4A, which is an undertaking which consists of or includes discharging functions of local authorities in England in connection with the placing of children with foster parents. Section 5, page 38, confirms that Ofsted, section 5, subsection 1, is the registration authority. And organisations that carry out the functions of an independent fostering agency must be registered. I'll use that at section 11 on page 41. Critical sections for our purposes are sections 13 and 14. Section 13 presupposes an application for registration made in pursuance of section 12. And subsection 2 requires the registration authority to be satisfied that the requirements of regulations under section 22 and the requirements of any other enactment which appears to the registration authority to be relevant are being and will continue to be complied with, so far as is applicable in relation to the establishment or agency. It shall grant the application, otherwise it shall refuse it. So, points to be made in that respect are that the wording of section 13 shows that 13.2b, the requirements of any other enactment which appears to the registration authority to be relevant. So it's for Ofsted to determine, subject only to traditional public law principles, which enactments are or which are not relevant. Once Ofsted has determined that a particular enactment is relevant, Ofsted must satisfy itself that those requirements are being and will continue to be complied with. And if so, shall grant the application, if not, shall refuse it. Section 14 deals with the cancellation of registration, so the other end of the spectrum, and says the registration may at any time cancel the registration of a person in respect of an establishment or agency on the grounds that the establishment or agency is being or has been at any time carried on otherwise than in accordance with the relevant requirements. And relevant requirements are defined in subsection 3 over the page, on page 46, as meaning the requirements of any other enactment which appear to the registration authority to be relevant. There are 22 sets out the regulation power, and that is the power to make regulations that are referred to in 13.2a. The relevant regulations are the Fostering Services England Regulations 2011. They don't say anything for our purposes, but I flagged them because what is relevant is over the page at section 23, which is on page 56. There's a requirement on the appropriate minister to prepare and publish statements of national minimum standards applicable to establishments or agencies. And those standards, subsection 1a, may in particular explain or supplement requirements imposed in relation to that establishment or agency. And subsection 4, standards shall be taken into account in the making of any decision by the registration authority under this part. I'm going to take you to the national minimum standards in a moment, but can I just take you to, so while we've got this open. And finally, there is the power of inspection contained in section 31, which is on page 59. And that's, of course, the power of inspection under which Ofsted has produced the report, which is the subject of this appeal. Now, the national minimum standards are contained in the supplemental authority bundle. Tab 2, page 27. At page 30 is the heading Legal Status of the Standards, and explains that the NMS of fostering services are issued by the Secretary of State under section 23. In the third paragraph, it says the standards are issued for use by Ofsted, who will take them into account in the inspection of fostering services. So they're relevant to Ofsted's inspection function. And relevantly, standard 13 at page 33. Standard 13 is recruiting and assessing foster carers who can meet the needs of looked after children. The relevant outcome is the fostering service recruits, assesses and supports a range of foster carers to meet the needs of children they provide care for, and is proactive in assessing current and future needs of children. And paragraph 13.2, people who are interested in becoming foster carers are treated fairly, without prejudice, openly and with respect, and so on. And finally, just while I'm in this tab, I'm just going to show you the Social Care Common Inspection Framework, the SCIF, as it's often referred to, which is at page 35. And this is Ofsted's guidance about how it will exercise its inspection functions in section 31. And in particular, paragraph 5 on page 40 sets out the evaluation criteria, which are the criteria that inspectors use to make judgments, including benchmarks of what good looks like. And those include, on page 46, it's page 47, in the context of the effectiveness and leaders and managers, it says areas of required evidence are, and there's a series of bullet points. The final bullet point is the extent to which leaders and managers actively promote equality and diversity. So that's the framework within which Ofsted is conducting its registration and its inspection powers. Turning then on to my submissions on this point. The first, that I don't understand it to be any part of the appellant's case that Ofsted was acting ultra vires under its powers under the Fair Standards And that must be right for the reasons that I've shown in respect to the legislation. It's for Ofsted to decide which enactments are relevant. Ofsted has decided that the Equality Act and the Human Rights Act are relevant. That decision isn't the subject of challenge, but in any event is plainly rational. Further, that is consistent both with the national minimum standards that I've shown you and also Ofsted's own policy in the SCIF.
Just to pick up the point that you meant, Ofsted has decided the Equality Act and the Human Rights Act is relevant. You mean in this case?
Well, in general, that it inspects.
Yes, but where do we get the in general? I perfectly understand why it might decide it was relevant. I'm not querying that for the purpose of my question. But you've taken us to a number of places where there might have been regulations made. There has been national minimum standards published. There's a SCIF which you've taken us to.
Yes.
None of which, unless I missed something, says in terms.
It doesn't say in terms of what you're quite right. But in order to assess equality and diversity and so on and so forth, the Ofsted does inspect against.
Right, so you hang the submission that Ofsted has decided upon the not numbered, but bullet point 9 or whatever it is on page 47 of our supplementary bundle.
It's part of the inspection framework.
But reference to legislation, there isn't any.
No, except that. The framework that I've just set out for you is the framework that was in existence at the time.
I'm slightly surprised, I'm bound to say, because if Ofsted, for reasons which might be perfectly understandable, says we will look to see that the Human Rights Act and the Equality Act are being appropriately observed by people that we inspect, you'd expect to see that rather front and centre of its public-facing documents.
Well, my lord, I can't add any further to. I've
No,
shown you.
all right. Well, I just wanted to check
I,
that when you said Ofsted has decided that we had the material which you rely upon.
I have taken you to the material that is relevant to the point I've just made, my lord, yes.
Thank you.
Of course, my lord, you also, of course, have the report in this case, which also makes it clear.
I didn't hear any of
you
that.
also have the report in this case, which makes it clear that those were matters that were inspected on the facts of this particular case.
I know it appears in the individual report, but I was asking a general question.
It's self-evident that Ofsted's powers and duties as the regulator of independent fostering agencies are different to and distinct from those of the Charity Commission, looking at two different areas of regulatory function. And as I've shown the court, Ofsted must satisfy itself that the relevant enactments are complied with. And in those circumstances, my lord, Ofsted must, of course, have regard to the decision of the Charity Commission. The weight to be given to that view is a matter for Ofsted. Ofsted isn't bound by the Charity Commission's view, and indeed it would err in law under sections 13 and 14 if it regarded itself as being bound.
So what in layman's language would you say the respective roles of the two regulators are?
Well, the Charity Commission, for example, in the relevant function for these purposes is that set out in the Charities Act.
I was looking for layman's language first.
Well, determining whether or not an institution is a charity, and part of determining whether or not an institution is a charity is determining whether or not the charity meets the public benefit objective.
Yes.
I'm sure I'm not a charity lawyer, I'm sure it's far more complicated than that, but that's my two-line take on what the Charity Commission does in this.
Whereas you?
Ofsted, on the other hand, will look to see whether an independent fostering agency, in discharging its functions as defined by Section 4 and the relevant regulations, is complying with those standards and complying in the context of this case with the relevant enactment.
But going back Ms. Hannett. First of all, I think perhaps it's putting the matter a little too colloquially to say that the Charity Commission decides whether an organisation is a charity. They don't have power to decide that. They only have the power to decide whether to register.
Yes.
Now you'll say I'm dancing on a pin. Register an organisation. It's assumed once it's registered that it is a charity,
Yes.
but the Charity Commission doesn't have any special power to determine ultimately whether something is a charity. And Mr O'Neill will also say that these two functions which you have described intersect, and so I want to know what you say about that, in relation to the fact that in order to determine whether to register an organisation, put it that way, or to deregister it, one of the things about whether an organisation should be registered is the public benefit element of a charity, and you can't tick the public benefit box if you are doing something illegal, and I put that in very general terms, and therefore that's the intersection here between is this illegal or is this something proportionate and fine, and what Ofsted are doing, which is this activity as something which is acceptable under the Equalities Act and the Human Rights Act, or is it not? And so those are the same questions, Mr O'Neill would say.
Yes. They are the same questions in some respects, but of course each is looking at it with its own regulatory focus. So Ofsted, of course, is looking at it in the context of the standards that it has to apply, in the context of it being an independent fostering agency. Fostering isn't the only activity that Cornerstone carries out, and it may be that when the Charity Commission looks at these questions, it's looking at the whole piece of the charity's activity. So it will be looking at all of the activities that it's carrying out. Ofsted, in inspecting on this particular purpose, is only concerned with fostering. That's the first point. It's focusing in on a particular aspect of the activities carried out by Cornerstone. And the point works both ways, my lady, in this sense that obviously Ofsted's view isn't binding on the Charity Commission. The Charity Commission must reach its own view on whether or not...
That's a different submission. You're saying that neither is bound by the other,
Yes.
and that's the submission you're making. But what I'm saying is, in fact, I'm not saying it, but I'm asking you to consider whether you accept that, in fact, the ground covered is the same ground.
Yes, I can't pretend otherwise. There's undoubtedly overlap, and even insofar as the Charity Commission have considered and determined an exemption applies, Ofsted has taken a different view. Of course, there's an overlap. It may not be a precise. I think the point that I was seeking to make with my first point is it may not be a precise overlap, because Ofsted is concentrating on a particular function, whereas the Charity Commission will be looking at the charitable activities as a whole. Now, it may be that is only one set of activities.
So you may have entirely different evidence.
Yes. And the decision may be taken at a different time. Circumstances may have changed. All of those points, right? It is. I can't shy away from the reality is that the Ofsted's decision does result in a position where it and the Charity Commission have taken different views. But ultimately, that isn't surprising when one looks at the two different regulatory functions they have. And no doubt,
They've taken two different views approximately a decade apart.
Indeed. And it's for the Charity Commission to in due course, if it wishes, to have regard to the decision of this court and to the decision of Ofsted to the extent that it...
I don't think it's a matter of whether it wishes. I think there'd be quite a lot of difficulty if it didn't.
Yes. Well, that may be the case, Melanie. I accept that. Although, of course, rather different in the context of taking account of a court's judgment and taking account of a view taken by Ofsted in an inspection. These two things are, of course, completely different, different matters.
The basis upon which you say you have to take account of the Charity Commission view is a perfectly simple public law basis that it's a relevant feature of the situation.
Yes.
It's not a question of preference or deference or anything of that sort. It's simply that they have a certain amount of information, they've reached a certain conclusion, we naturally must look at that.
Yes.
It's a relevant consideration.
It's a relevant consideration.
I entirely accept that. It's a relevant consideration, and under classic public law principles, it's for Ofsted to decide what weight to place upon it. Now, of course, my learned friend Mr O'Neill posited an example yesterday, the Health and Safety Executive having gone in the day before Ofsted and produced a report that gave a particular organisation a clean bill of health, Ofsted going in the next day and reaching a different conclusion. Now, maybe that in those circumstances, Ofsted's decision, its treatment of the Health and Safety Executive would be irrational. But the point is, it's not bound, it's never bound by a decision of a separate regulator. The weight to be placed upon it may vary depending on the context and the circumstances. And of course, the weight and the approach that Ofsted takes to a different regulatory body's decision would always be the subject potentially of a judicial review challenge, as here.
Right, well now you've given us a number of arguments in your skeleton argument about this, including the different status of charities and non-charities and so forth. And if we have those matters in mind, is there much more you need to say?
No, I think there's just one point for completeness to make, and that is that the text of section 193 doesn't provide any basis for effectively taking away the virus that's granted my submission by the Care Standards Act. And there isn't anything at all to support the friend's submission that carves out an exclusive domain to the Charity Commission to determine the application of section 193.
I think you go further and say that there's material within the statute itself that would be superfluous if this ground of appeal was well-founded.
Well, I know at the time, I can deal with ground 4 extremely quickly.
Right, what have we got left?
Ground 4, which is Cornerstone's recruitment policy, breaches the Human Rights Act. I don't intend to say anything further than that set out in my submissions and my skeleton argument. And then there's ground 5, that the report breaches Cornerstone rights under Article 9. And again, really, 2 points. First of all, that if I'm right about the application of the Equality Act, if Ofsted's got that right, it simply cannot be a breach of Article 9, 10, 11 or 14, because absent a challenge to the Equality Act, Parliament has assumed to have got the ECHR balance right in the Equality Act. And in fairness, this is really the inverse of the argument taken against Ofsted below, the point that's not appealed.
Right, well, with that, shall we break at this point, and
yes.
You can then reflect on what you want to say on either of those two remaining grounds. We're clearly
I will be
well up
15
on
minutes
time.
at most
Right.
after lunch.
That will then give Mr O'Neill a fair opportunity to reply. All right, 2 o'clock.
Well,